Okay, let's dive in. Imagine this. You're maybe running a business or perhaps dealing with a tricky international family matter. You need to get a basic legal document, like a simple summons to someone living overseas. Should be straightforward, right? But suddenly you find yourself just swamped in bureaucracy, diplomatic pouches, consular stuff, maybe even things called letters rogatory. Your simple task has become, well, a bit of an international headache.
Yeah, that exact procedural nightmare, that sort of black hole of paperwork, is precisely what South Africa aimed to fix with a very specific piece of law. Today, we're doing a deep dive into the Reciprocal Service of Civil Process Act 12 of 1990.
Okay, that title sounds a bit heavy, I admit, but our mission here is to break this act down for you. We want to give you the essential pieces, whether you're just curious or, maybe studying law. Think of it as the quick guide to this legal shortcut.
And it's definitely not some dusty old law nobody uses. I mean, yes, it was signed back in 1990, but it's very much alive and relevant. We're looking at the consolidated version, which reflects updates and reviews right up to March 2025. It's really fundamental for predictable international service.
Right, let's start with the basics. Why does this act even exist? What's its core purpose, according to the preamble?
The preamble itself sums it up nicely. It's there to provide for a reciprocal service of process in civil matters in the Republic and in designated countries. Basically, it's about creating a smooth, reliable way for one country's court documents to be served in another, and, importantly, vice versa.
That word reciprocal keeps coming up. We hear it a lot, but what does it really mean in this legal context, like practically speaking?
Practically, it means mutual convenience, built on trust. Before this act, if a South African court needed to serve, say, a summons in country X, well, it was complicated. You'd be tangled in diplomatic procedures, judicial requests. It could take months, honestly. Reciprocity means country X agrees, okay, we'll serve your documents sufficiently, but only if South Africa agrees to do the same for theirs. It's a kind of quid pro quo, a diplomatic agreement where both sides ease up a bit on sovereignty hurdles for the sake of making civil justice actually work across borders.
Okay, trading some friction for efficiency, that makes a lot of sense. Now, let's get into the nitty-gritty definitions in Section 1. What kind of paperwork are we talking about? What exactly is process?
Process is defined quite broadly, actually. It's any process in a civil matter and includes any document relating to such matter. So think initial summonses, notices of motion, subpoenas, maybe interim applications, essentially anything that gets a civil case started or keeps it moving. But, and we'll come back to this, it's generally before you get to enforcing the final judgment.
Right. And this whole system only works with specific partner countries, the designated countries.
Exactly. A designated country is simply one that the minister has officially named under Section 2 of the Act. And just a quick administrative note here, something important if you're dealing with this directly. The minister responsible is now formally the Minister of Justice and Constitutional Development. That function was transferred recently.
That's good to know. So how does a country actually get designated? Is it a whole new law every time they add one?
No, and that's actually quite clever in Section 2. It gives the minister flexible control. They can designate a country just by publishing a notice in the Government Gazette. And just as easily, they can withdraw that designation using the same notice system.
So the minister is like the date keeper.
Yeah.
They can decide who's in and who's out based on maybe diplomatic relations or stability without needing Parliament each time. That seems like a smart way to balance efficient justice with, keeping control over who we have these arrangements with.
Exactly. It sets the stage. So now let's see how it works in practice. Section 3 deals with service coming into South Africa. Let's say a company in Germany, assuming it's designated, is suing a South African resident. How do they serve the summons here using this act?
Okay, this is where the shortcut part really kicks in, right?
Precisely. Instead of wading through complex international treaties or diplomatic routes, the German court official sends the process directly. It goes to the South African magistrate in the specific area, the jurisdiction, where the person needs to be served. That local magistrate becomes the key contact point.
Okay, but before we get to what the magistrate does, we need to stress the big limitation here. It's mentioned repeatedly, isn't it? What does this act not cover?
Yes, absolutely critical to understand this upfront. The entire streamlined process we're describing explicitly excludes anything relating to the enforcement of a civil judgment.
Let's pause on that exclusion. Why draw the line there? Why is serving the initial summons okay under this act, but serving the final order to pay up or seize assets is not?
It really boils down to sovereignty and, well, power. Serving a summons is essentially just giving notice, hey, you're being sued, show up. Enforcing a judgment, though, that's different. Collecting a debt, telling the sheriff to seize property, compelling someone to do something based on a foreign court order, that's one country projecting its legal power inside another country's borders. It's a much bigger intrusion. That kind of action typically needs very specific, separate treaties about recognizing and enforcing foreign judgments. This act keeps things cleaner by just handling the initial notification phase. It gets the parties to the table, so to speak, but doesn't deal with dividing the winnings.
That's a really clear distinction. Okay, so assuming it's just a notice or summons, not an enforcement issue, the magistrate gets the document from overseas. What happens next?
First, verification. The magistrate needs to be satisfied that the process was, in fact, lawfully issued by the court in the designated country. Once they're satisfied on that point, they do the key step. They endorse the process for service right here in South Africa.
The endorsement. That sounds like the magic wand bit. What does that magistrate's signature actually achieve legally?
It's huge. That signature effectively domesticates the foreign document for service purposes. The act says, once endorsed, it shall be served as if it was a process issued out of the court of that magistrate.
Wow, so it basically becomes a local South African court document for the purpose of getting it delivered. It bypasses all the usual foreign service rules.
Exactly. That little phrase, notwithstanding the provisions of any other law, is incredibly powerful for lawyers. It means you forget about the complex rules in the Uniform Rules of Court or Magistrates' Court rules about serving documents overseas. The foreign document, once endorsed, is treated just like local paperwork. The local sheriff serves it. What might have taken months through diplomatic channels can now happen, potentially, in days or weeks.
That's a massive time and cost saver. What if the document arrives in, say, German or French? Is there a language issue?
Yes. Section 3, subsection 2 covers that practical point. If the process isn't in English or Afrikaans, the magistrate can't endorse it. It needs to come with a sworn translation into one of those languages. Makes sense. Our officials and the person being served need to actually understand what the document says.
Okay, that covers documents coming in. Let's flip it. Section 4. Service going out of South Africa. How does the Act help South African litigants sending their court papers to someone in a designated country?
Again, it's about streamlining. It removes hurdles. For documents going out, the process can be issued directly by the registrar of a high court division or by the clerk of a magistrate's court.
And what's the main simplification there compared to how it might work otherwise?
The key phrase here is without leave of the court in question. Normally, under South African procedural law, if you want to serve court documents outside the country, you often need to apply to a judge first. You have to ask the court's permission, get leave, to serve abroad. That means an application, affidavits, maybe a hearing. It takes time and costs money.
Right. So this act basically says, for these designated countries, you can skip asking the judge for permission at this stage. The court admin staff, the registrar, or the clerk can just issue it.
Precisely. The registrar or clerk handles the issuance for sending it out to the designated country. It's a significant procedural shortcut. It speeds things up considerably for the South African party who needs to get that initial process served overseas quickly. And, just to hammer it home, the same limitation applies. This outgoing process also excludes anything related to enforcing a civil judgment. That line holds firm both ways.
Okay, so the act speeds up getting the notification served both ways. But there's always that question with foreign documents. Authenticity. If I get served with something that looks like it's from a court in, say, Lesotho, how do I know it's real? That's the whole issue of authentication, isn't it?
Yeah.
How does this act deal with that?
Authentication is normally a real pain for international documents. You often need seals, ribbons, certificates from consulates, maybe even government departments, all verifying that the signature on the document is genuine. It can be a whole chain of verification. Section 5 of this act just cuts right through all of that complexity.
Cuts through it how? Does it just waive it completely?
Yes, basically a complete waiver for documents under this act. Section 5 states quite clearly, notwithstanding the provisions of any other law, the authentication shall not be required for service under this act. Because the whole system is built on that idea of reciprocal trust between the designated countries and South Africa, we don't need that complex external proof anymore.
So if you don't need the complicated apostilles or consular seals, what do you need? Is there any check?
Yes, there's a much simpler substitute, certification. Instead of involving diplomats or foreign ministries, the document just needs to be certified by an appropriate court official in the designated country. That could be a magistrate, a registrar, or a clerk of the court there. They just need to certify that the document is an original or a true copy or a true translation if needed. It shifts the burden from a complex diplomatic process to a simple confirmation by a trusted peer within the foreign judicial system.
That really underscores the philosophy of the act, doesn't it? Replacing bureaucratic hurdles with sort of professional trust between the court systems. Trusting that the clerk or magistrate in the other country is doing their job properly is much faster than waiting for multiple stamps and seals.
Exactly. So if we pull it all together, the Reciprocal Service of Civil Process Act is, well, it's a really practical tool. It facilitates international dealings and access to justice. It helps keep cross-border civil cases moving predictably, efficiently. But it does so within very clear boundaries, sticking only to that initial service of process, not the enforcement part. It carefully balances our national sovereignty with the everyday reality of needing to interact legally across borders.
Right. So the main thing for you, the listener, to take away is this. If you're dealing with basic civil court papers, not judgment enforcement involving South Africa and one of these specific designated partner countries, this act provides a crucial legal shortcut. It aims to cut out the bureaucratic delays and the complex rules you might otherwise face.
Which brings us right back to that big exclusion we kept mentioning. Since this act from 1990 deliberately doesn't cover enforcing civil judgments, it makes you think, doesn't it? If you successfully sue someone overseas and get a judgment here in South Africa, but the person or their assets are in that designated country, what do you do then? What legal frameworks or maybe specific international agreements do lawyers have to use to actually collect that debt or enforce that order abroad? Exploring that question takes you beyond this act into a different, often more complex area of international law, usually involving specific treaties focused purely on making foreign judgments count,